Ladies and gents, again, for the first half an hour to 45 minutes, you'll be hearing a little bit of background noise, perhaps. Again, it's the inverter. We have a load shedding here till 6 o'clock. Now, ladies and gents, what we've been looking at the first 2 evenings has basically been what happens before a person passes away. I mean, up until the point at which you pass away, you either die testate, die intestate. And it just depends if you made a valid will or not. But what we've seen is that whether you die testate or intestate, someone needs to wind up your deceased estate. And that someone is going to be called the executor. So this evening we are moving on to what happens post-death. In other words, the winding up of the deceased estate. Now, ladies and gents, there is a theoretical as well as a practical element to this. From a theory point of view, you need to know the different steps that need to be taken in winding up a deceased estate. I will summarize it for you and give it to you. Again, for your own benefit, I do suggest you take notes. Once we've been through the whole process from beginning to end, the only thing left for us to do is to learn how to draft the liquidation and distribution account. And we'll leave that for last, as it is probably the most difficult element, and we'll try our best to obviously make sure that we understand that aspect. So we're starting off this evening with learning what is the job of the executor. Now, ladies and gents, obviously, how would you become an executor? Someone would have died with a valid will, and they would have appointed you as the executor. So the will would have appointed you as executor. We looked at it yesterday, that every will has an executor clause as well, choosing someone to wind up the deceased estate. But you could also become an executor of an intestate deceased estate. Now, obviously, there is no will that's appointed you, but someone might pass away intestate, and their family members would then perhaps approach you and say, look, sir or ma'am, you know, this person passed away and we need help winding up the deceased estate. There is no will. So in other words, the family members would then come and appoint you for assistance, and you would become the executor of the deceased estate. I mentioned to you last night already that as executor, you are entitled to 3.5% of the gross amount of the deceased estate. In other words, the value or the total value of the assets in the deceased estate. And that will make sense as we go along and as we learn how to draft the liquidation and distribution account. Right, before we can get there, ladies and gents, let's just make sure we have the theory wrapped up and we understand the processes or the steps involved in winding up a deceased estate. Like I mentioned, I've summarized it into 6 clear steps that you need to follow, and I would suggest you take your notes in this regard. So you are the executor of the deceased estate, whether you were appointed by will or whether it was intestate and the family members appointed you. What is the first thing you need to do? Now, ladies and gents, step 1, we need to realize that just because we've been appointed as an executor of a deceased estate does not mean we can start acting as an executor. We have to first obtain what we call a letter of executorship from the master's office. We need to obtain a letter of executorship from the master's office. This gives us the authority to commence our job, or to commence all the steps that we're going to learn involved in winding up a deceased estate. Now, how do we obtain this letter of executorship? Well, that's step 1. Step 1 is the process, the things we need to complete to obtain this letter of executorship. What we call it, ladies and gents, we say we need to report the deceased estate. So you need to report the deceased estate to the master's office so that you can receive the letter of executorship. Ladies and gents, there are certain documents you need to give the master's office when you are reporting this deceased estate. If you do not provide them with the following documents, you will not obtain a letter of executorship. So let's learn what are these documents that we need to give the master's office to get this letter of executorship. Well, first things first, ladies and gents, there are 3 standard documents you need to complete. A lot of the law firms you work at will have these documents already somewhere in their office systems. Or what could also happen is if you are not in possession of these documents, you can also download them from the internet. They are easily accessible. Now, the documents are called the following. The first document we call a death notice. So the first document you need to complete is a death notice. Ladies and gents, the death notice is pretty much just personal particulars of the deceased person. It's a standard document with a bunch of questions on that you just need to fill in, and all questions are just personal details of this deceased individual, right? As I've said, it's called a death notice. The second document is what we call an inventory. I'm sure you've heard of the term inventory from civil law, where the sheriff goes and attaches people's assets and makes a list of all the assets they have in their home. Same concept. An inventory is a list of all the assets of the deceased person. So you need to complete a form where you indicate whether or not the deceased person had immovable property. What movable property did they have? How much money did they have in the bank? Is there any policies that are going to pay out into this deceased estate? All right, so the master's office wants to know from the get-go what assets are in this deceased estate. Now, the way they obviously establish this is we need to complete this inventory, the list of assets, and you need to put down the value, the estimated value of these assets. Now, ladies and gents, this inventory also serves a second purpose. Other than the master's office wanting to know what assets are on the deceased estate, they also want to know if the deceased estate is worth more or less than 250,000 Rand. I'll say it again. This inventory will also tell the master's office if this deceased estate is worth more or less than 250,000 Rand. If it is less than 250,000 Rand, ladies and gents, the master's office will not give you a letter of executorship. They will give you what we call a letter of authority. Ladies and gents, the process of winding up an estate worth less than 250,000 Rand is a lot easier than the process of winding up an estate worth more than 250,000 Rand. If a deceased estate's assets is worth less than 250,000, we call it a Section 18 subsection 3 estate. So an 18.3 estate. That means the total asset value in the deceased estate is worth less than 250K. What is the consequences thereto? The executor will not receive a letter of executorship. They will receive a letter of authority. Secondly, you will see step 4. We're going to come to it now. That is drafting the liquidation and distribution account. That's what makes the winding up of the deceased estate so specialized, and not anyone can do it, ladies and gents. I mean, not all lawyers can do it. Very few lawyers can actually do it. I mean, as a matter of fact, you can say lawyers specialize in this. And if you have a deceased estate that's an 18.3, less worth than 250K, you do not need to draft the liquidation and distribution account. So you don't have to do that. And that is why you often see family members winding up a deceased estate worth less than 250K. Why you often see family members walking around with a letter of authority. Because a lay person is probably capable of winding up the deceased estate without any professional help, if the estate is worth less than 250K. And why? Because you then do not need to draft your liquidation and distribution account. Okay, so just keep that at the back of your brain somewhere. That's the point of the inventory document. Then we said there is a third standard document that you also need to complete. This document is called acceptance of trust as executor. So 5 words. Acceptance of trust as executor. Ladies and gents, this document is now personal details or personal particulars of you, the executor. The Master's Office wants to know who you are that is going to be executor of the deceased estate. All right. So remember, we're trying to learn how to wind up a deceased estate here. We said step 1 is we need to report the deceased estate so that we can get a letter of executorship. Now we're learning what documents must we give the Master's Office when reporting this deceased estate. We said there's 3 standard documents we need to complete: death notice, inventory, and thirdly, the acceptance of trust as executor. Again, ladies and gents, if you are not in possession of those documents, you can get them off the internet. Other than completing those 3 documents, there is other documents that the Master's Office wants to be provided with, that we need to provide the Master's Office with. Now, I want you, before I go any further, just to see the full picture of this. If you are executor of a deceased estate, it means you are in charge. You are taking over that deceased person's personal estate. And you're given the responsibility to close down that estate in the most profitable manner possible, so that the beneficiaries of that estate can maximize their inheritance. Okay, that would be the basic idea behind this, right? So it's a large, huge responsibility because you are sitting in possession of this person's entire estate. So from the get-go, the Master's Office wants to know what is going on in this deceased estate. The reason is, if the Master's Office knows from the beginning what's going on in this estate, then they can monitor you as executor to make sure you are not stealing money, misappropriating money, committing fraud, acting negligently, all those things. Because from the get-go, they have a clear picture of what's going on. Obviously, they want to make sure that everything is dispersed off in the proper manner and that there is no foul play involved. That is why we report the estate. So the Master's Office also knows what's going on in this deceased estate before they allow you to take over the estate as executor. So think to ourselves, they now have our personal details. They know the personal details of the deceased. They also have a list of assets and the value of those assets, so they know what kind of money is in this deceased estate, so that we can't steal anything or get rid of something or misappropriate anything. But there's other pieces of information that are very, very relevant to a deceased estate. First of all, if I tell you John died, does that mean anything? Well, do you have conclusive proof that John died? No, you just have my word. Now, the same concept, if I go to the Master's Office and say, right, John passed away, I need to be the executor, so please give me a letter of executorship. What does the Master's Office want from me to prove that John has passed away? Obviously, John's death certificate. So you will also need to give the Master's Office the death certificate of the deceased person as proof that this person has indeed passed away. Right. If you pass away testate with a valid will, what does the Master's Office need to see so that they have a clear idea of what's going on in this estate or who should get what? Obviously the will, right? So you need to also give the Master's Office the original will. Now, ladies and gents, just kindly also be reminded to be muted, ladies and gents. I'm getting some noise in the background. Right. But now let's ask a question, because I want us to apply logic here and not study like a parrot. I'm giving the Master's Office the original will, so the Master's Office can monitor me to see who's supposed to get what. Because they want to make sure that I, as executor, are giving the right beneficiaries the right things in terms of what that deceased person's will is saying. For me, that will gives 2 important pieces of information to the Master's Office. Number 1, that will obviously appointed me as executor. So the Master's Office now has confirmation that yes, Carl Kitzman, you were indeed appointed as the executor in the will. So it's not like I'm trying to defraud anyone. I was the rightfully appointed executor. And the Master's Office can see this from the will. Secondly, from the will, what's also very relevant there is obviously it indicates who are the legatees and who are the heirs, right? It indicates the beneficiaries of the deceased estate, which is obviously very, very relevant for the Master's Office to see who's supposed to get what. Just quickly before I go any further, I don't see the full name, it looks like Najabullah. Just check there, you are not muted. Thank you so much. Right. Now, the question we've got to ask ourselves is what happens if a person passes away intestate? Remember, there's no will. So there's no document appointing me as executor, and there's no document indicating who the beneficiaries are of the deceased estate, because the person has passed away intestate. So somehow we need to supplement that information. Remember what I told you. If they died intestate, how would you have been appointed? The family members would have come to you and asked for your assistance. All right. So we probably need two documents or two affidavits, let me rather say, to supplement this will. One to supplement our appointment, and secondly to supplement who the rightful beneficiaries are. Right. So how do I supplement my appointment? You complete what we call a nomination affidavit. I'm going to say it again. You complete a nomination affidavit. This is where the close family members under oath appoint you as the executor of the deceased estate. We call it a nomination affidavit. So that will cover the will in terms of our appointment as executor. But remember, what's the main thing of a will? It's the appointment of beneficiaries, right? The legatees and the heirs. Now we don't have a will. So what happens if someone passes away intestate and you're the executor? You then need to do your calculations to see who's entitled to what. Remember what we learned Monday evening, those 5 different rules. You need to apply those rules to figure out who is the rightful beneficiaries of this intestate estate. You then complete what we call a next of kin affidavit. I'll say that again. You complete a next of kin affidavit. Ladies and gents, I think it is Glenn. You are not muted. Thanks, Glenn. Right. Now, this next of kin affidavit, ladies and gents, is where you under oath indicate, in terms of the rules of interstate law, who the rightful beneficiaries are. We've learned this. You know, if there's a spouse and kids, they're going to get everything. If they're not there, it's the parents. If they're not there, it's the deceased brothers and sisters and half brothers and half sisters. Blah, blah, blah. We've learned this on Monday already. Okay. So those two affidavits will supplement the will in the case of an intestate estate. And I want us to think that it makes sense, you know, because we need to give the Master's Office's relevant information. Now I'll ask you another aspect. The Master's Office can now see that you're the executor or the appointed executor, and they can also see who the beneficiaries are. But let's think what we've learned so far this week. Is there not another element that has a huge impact on the deceased estate? Outside of testate and intestate law, what did we learn we got to look at first? The marriage regime. Whether or not that deceased person was married and what type of marriage they were entered into plays a huge impact in this deceased estate. I mean, we know we're married in community of property. Half of that estate is your spouse's. You know, if you're married out of community property with accrual, you'll have to do your accrual calculations to see who's entitled to what. Obviously, if you're married completely out of community of property without accrual, then it plays no impact. But the point being, whether or not they were married is huge. So what does the Master's Office want? They want a marriage declaration, ladies and gents, we need to give a marriage declaration to the master's office indicating whether or not this deceased person was married. Ladies and gents, if we say they were married in community of property, what must we give the master's office? The marriage certificate, right? The master's office will then want the marriage certificate. If someone is married out of community of property, what does the master's office want? The antenuptial contract. So give proof of the type of marriage that the deceased person was involved in, because that obviously has a huge impact on how we are going to distribute this deceased estate. Right. Other than marriage, there's two more things we need to consider. Firstly is, we're going to have to give certain people certain things, right? So we're going to have to give the legatees and the heirs their inheritances. We also know we're going to take 3.5% of the total asset value of the deceased estate. So the master's office wants proof that everyone is indeed who they say they are. I can't say John must get 500,000. I need to prove that this person here next to me is John. Where's John's ID copy? In other words, right? So you need to give the master's office identity documents, ID copies, certified ID copies of all the beneficiaries of the deceased estate, as well as of yourself as executor. Because if Carl Kitzman was appointed as executor of the deceased estate, and I go to the master's office and say I'm Carl Kitzman, they're going to say, prove it. Here's my ID document. All right? So the ID documents of the beneficiaries, as well as the executor, certified copies thereof, please, must be given to the master's office. So the master is also comfortable that everyone has proved themselves to be who they are, because it's obviously relevant for purposes of divesting this deceased estate. The last thing that we also might need to keep in mind, ladies and gents, and I think I shared this with you last night. You will recall I said the master's office might request that you as executor provide security. All right, and we said that's basically a bank guarantee that you have X amount of money readily available should you act negligently and cause damage to this deceased estate. So there might also be a security document you need to give the master's office with proof that you do indeed have security for any losses that the deceased estate might suffer. Now, ladies and gents, in a nutshell, you're going to put all these documents together and you're going to go and drop it off at the master's office. You're going to put a letter in front, and obviously you're going to say find attached 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And you're going to ask the master's office to give you a letter of executorship. So that's step one, ladies and gents. If you're the appointed executor, report the deceased estate to the master's office. They need a clear picture of what's going on before they will give you a letter of executorship. And you can only start acting as executor of the deceased estate once you have this letter of executorship. Just to recap, what documents did we have to give the master's office when we reported the deceased estate? We said there's 3 standard documents we needed to complete: death notice, inventory, and acceptance of trust as executor. Then we said outside of that, give the master's office the death certificate to prove this person has passed away. Give the master's office the original will of this person so the master's office can see that you're the appointed executor and they can see who the nominated beneficiaries were. If the person died intestate, you'll need to supplement that information. Do a nomination affidavit for your appointment and do a next of kin affidavit indicating, according to the rules, who are the people that are entitled to inherit from the deceased estate. We said marriage plays a huge part. Give the master's office the information relating to the marriage, whether it's a marriage certificate or antenuptial contract, or just simply a marriage declaration stating that the person was unmarried. But the master wants confirmation in this regard. Other than that, we said we need identity documents of all the beneficiaries. You know, if the deceased children is supposed to inherit, then we'll probably give birth certificates, right? Any way to identify this person, we need to provide the master's office with proof thereof. And lastly, we said we might be asked to give security. So that form of security would possibly also accompany those documents, depending on what the master's office wants from us. You'll take that all to the master's office, and you'll wait for the master's office to provide you with a letter of executorship. Once you've received that letter of executorship, ladies and gentlemen, you are now the executor of the deceased estate. That is step one. It's quite a big step, but that's how we get going. Once you've received this letter of executorship, you can move over to step two. Now, ladies and gents, what is step two? Nice and simple. You are now going to open a deceased estate's bank account. Step two, you are going to open a deceased estate bank account. Now again, let's apply logic and understand why we are doing these things. Now, ladies and gents, this deceased person who's passed away, they might have had cash on them or cash at their home. They might have money in different bank accounts. They might have money in a FNB check account. They might have an ABSA savings account. They might have a 32-day call account. They might have money in investments. They might have all kinds of ways they could have different forms of cash. They might have policies that are going to pay out into the deceased estate because they've passed away. All these things are real possibilities. Now remember, we are in charge of taking control of all that money because we're ultimately going to have to disperse this money according to what the will says or according to what intestate law says, depending on the way they passed away. So what's required of us is to open a deceased estate's bank account and transfer all monies in this deceased estate into this bank account that we as executor solely have access to. We don't want other people touching this money. We are in control of it. Very easy to do, ladies and gents. You can open this deceased estate's bank account online, or you can go into a bank with your letter of executorship, and one of the bankers there will assist you in opening a deceased estate's bank account. You will then transfer all the money into this bank account. From another point of view, think to yourselves, if all the money is in this bank account, the master's office can also monitor it to see that you are not using the money negligently or stealing any money. Why? Because the bank account will obviously have bank statements. So it will be clear to see what money is being taken out of that account and what money has been put into the account. That is why we have to open this deceased estate's bank account. Right. Now, if you think to yourselves, ladies and gents, at this stage, after step two, we have our letter of executorship, we've opened this bank account. But if we look at the picture as a whole, we now know exactly what assets were in the deceased estate. Why? Because we did that inventory as part of step one, where we listed the assets. And we've also transferred all the money into the deceased estate bank account. So we know what asset values in the deceased estate. Now, you remember yesterday, I told you it will become more and more clear as the week goes on that there's a certain ranking in which we disperse assets from the deceased estate. First one was we've got to pay all the creditors of the deceased person. Secondly, look at marriage. Thirdly, sort out the legatees. And lastly, give what's left to the heirs. That's the ranking. So at this stage, we know what the assets are. We know what the marriage regime is. We know who the legatees and the heirs are. But what don't we know? We don't know who are the creditors of the deceased estate. And remember, they're ranked number one, hey? So we don't know who's entitled to what. That's the problem we sit with. So we need to start figuring this out. Who are the creditors? So that's what you're going to do on step three. Step three is we need to establish who are the creditors of this deceased estate. How do we go about doing that? Right. So we have to do what they call a notice to creditors. This is done in terms of Section 29 of the Deceased Estates Act. So we have to do a notice to creditors in terms of Section 29 of the Deceased Estates Act. So what is this? Ladies and gents, a notice to creditors is, by law, we have to place an advertisement in the Government Gazette and the local newspaper. So we must place an advertisement in the Government Gazette and the local newspaper. Just for interest's sake, ladies and gents, even in civil law, you will hear the term local newspaper sometimes. Just so that you understand what that means, local newspaper means the place where the person lived in the last 12 months of their life. So if this deceased person lived in 3 different towns in the last 12 months of their life, you might have 3 different newspapers that you need to advertise in, okay? Because that's what local newspaper is, where you live the last 12 months of your life. Now, ladies and gents, this advertisement calls upon any creditors of this deceased estate to come and lay a claim against the deceased estate. It gives them no more than 3 months from date of advert to come and lay their claim. So this advertisement says, John has passed away. If John owed anyone money, please, here's the contact details of the executor, here's the email address, please lay your claim against the deceased estate. You have 3 months from here on out to lay this claim. Now, let's think logically about this. Your big institutions have people specifically appointed to look at the local newspapers and look at the government gazettes and look for adverts like this. The banks, etc., have people nominated to do these type of things. So they can pick up if this advert comes across and they can have a look at John and see, oh, John was a client of us. We F&B. So we F&B, John owes us money on the bond for his house and he owes us finance on the vehicle. So we're going to lay a claim for that money. F&B would obviously be a creditor of the deceased estate. But from a logical perspective, the problem you have is not all creditors know about this. Not all creditors look for things like this. So it can be a bit of a challenge. Now, what do I mean by that? What happens if you place this advert in the government? Remember, we're on step 3. So what happens if you place this advert in the Government Gazette and newspaper, calling on any creditors who John owes money to lay their claim in not longer than 3 months from now? Then let's say 4 creditors lay their claim. Okay. 3 months have passed, only 4 creditors. I'm like, okay, John only had 4 people that he owes money to, or 4 institutions that he owes money to. Great. I then move over to step 4, step 5, possibly even step 6. And then 1 or 2 other people come and say, sorry, I didn't see this advert. I only now found out that John passed away. John owes us lots of money. He has proof. Because that's what it means to lay your claim. To lay your claim is to come and prove that, that this person owed you money. The problem I have now is I've already done step 4, 5, or 6, and I haven't factored in these people's claims. Now you could argue, but they are late. They acted outside the 3-month timeline. But what do we do in South Africa if we are late, ladies and gents? We do condonation. I might look at it and say, as executor, I'm not accepting this because I don't know if your claim is really that strong and you are considerably late. That means that me and this creditor are now in disagreement because they're saying I must include their claim and I'm saying you're late. This dispute gets referred to the master's office, and the master must make the final decision if I need to include this claim or not. If they say include it, it means I must go back to step 3 because my step 4, 5, and 6 is wrong because I did not factor in this money that the deceased owes them. And it can cause a huge delay in the process. So what I'm trying to tell you is, by law, what you need to know is you need to place the advert in Gazette and local newspaper calling upon all creditors to lay the claim against the deceased estate in not longer than 3 months from date of advert. Right, that's what the law says we must do. So we can figure out who the creditors are. But now from a practical perspective, I'm telling you, you run a bit of a risk by doing that, because as I explained, problems could come later down the line. So my advice would be, on top of that, speak to the deceased person's family members. Look through the deceased person's bank statements, because from bank statements you can gather, who the deceased person was paying, through debit orders. You can't see how much they owe, but you can maybe figure out, who the creditors are of this deceased person. Pick up the phone and contact these institutions and say, listen, I've just placed the advert in Gazette and local newspaper. This person has passed away. If you have a claim, from what I can see from the bank statements, it looks like John was paying you off. So if John still owes you money, please, here's the details, please lodge your claim. By doing that, I make sure that all the rightful creditors, or I give myself a better chance of making sure that all the rightful creditors come and ultimately lodge their claim against the deceased estate. Because you are taking a bit of a risk by just putting it in the newspaper and hoping that everyone sees it. Because it doesn't always happen that way, ladies and gents. Unfortunately, I think we can think for ourselves that it doesn't always happen. Not everyone is going to see it. So take the extra step. I mean, you can give that job to your receptionist and say, look, these institutions, please give them John's details, speak to the right people, make sure they lodge their claim so that we have no issues down the line. I mean, it's all about time management, getting these things done as quick as possible and avoiding any unnecessary delays. But that is step 3, figuring out who the deceased person owed money to, because we know creditors are ranked number 1. Okay. At this stage, after step 3, we actually know everything. Ladies and gents, let's just be muted. Someone is unmuted. There we go, thank you. Now, we have a clear idea of exactly what's going on in this deceased estate after step 3. We know what the assets are. We know what the liabilities are, in other words, who the creditors are. We know the marriage regime. We know who the beneficiaries are. We have all the information in front of us. That was the whole point of steps 1, 2, and 3, to gather all the correct information. We can now move on to step 4. Step 4 is you now need to draft the liquidation and distribution account. Ladies and gents, I'm going to refer to it from here on out as the L&D account. Okay? If you hear me say L&D account, please know it is the liquidation and distribution account. Now, ladies and gents, I am going to start discussing that a bit later this evening, but in a nutshell, we will be spending the whole of Thursday and the whole of Friday learning how to draft that account. Now, the problem we have with wills and estates is that any subject, criminal law, civil law, labor law, wills, the process of a deceased estate, you can probably pick up a book and study it. But it's difficult to study something that's of a practical nature if you don't understand the purpose of it. And that's what we're going to try and achieve tomorrow and Friday, is to understand what we are trying to do in this liquidation and distribution account. What is the point? Because you hear me say step 4 is to draft the liquidation and distribution account. However, a liquidation and distribution account consists of a number of different accounts. There is 1, 2, 3, 4, 5, 6. 6 accounts that it consists of.
I'm not on a break, but
we need to learn how to draft.
Yes, the Monday it rained and it.
Ladies and gents, please look down at your laptops. You are not muted. Make sure you are muted. There we go. Right. We need to learn how to draft all 6 of these accounts. And it's coming in the exam. And it is the most difficult part of L&D. It's the most difficult part of being the executor of a deceased estate. As you can see, steps 1, 2, and 3, yeah, it's admin. It's not difficult, it's just admin. Steps 5 and 6 is just admin. Where the skill comes in is step 4. That's why I said if you have a letter of authority, you can do this, because you don't have to do step 4. You don't have to do step 4 or 5. I mean, you'll see now when we get to step 5 why I say so. So it makes it easier. But when you're dealing with a bigger estate, you need professional assistance. And if you want to indulge into distributing and winding up deceased estates, because there is a lot of money in it, there is, from a financial perspective, good fees involved over here. But if you want to go this route, once you are done with your clerkships and so forth, you need to learn how to draft a liquidation and distribution account. And especially for those who did not have this subject in varsity, I believe after I left, it became a choice subject in university, which I don't agree with because there's a board exam you need to pass on it anyway, so it doesn't make sense. But nevertheless, you need to learn how to draft this liquidation and distribution account. Even if you're not going to use it in practice, you're going to need to pass an exam on it. That's the whole concept behind it. And it's going to be a struggle to learn how to draft this account if we don't understand it. These 6 accounts that comprise this liquidation and distribution account. And like I said, that is what we're going to focus with on the whole of tomorrow and Friday, and we'll start touching on it this evening as well. So that is step 4. By step 4, you can make a note. You have to draft the liquidation distribution account, and just make a note. We are going to learn how to do that last. It is the biggest part, so we'll leave it for last. Right. Let's move over to step 5. We're almost there, ladies and gents. We said there's 6 steps involved in this process. Step 5. We have to do our second advertisement. Okay. Now, without touching on what the liquidation distribution account is yet, I'm just going to mention that that account shows the full picture. It shows exactly who's getting what. That's the liquidation distribution account. It shows how much assets there is. It shows who the creditors are. It shows how much the spouse is going to get. It shows how much the legatees are going to get. It shows how much the heirs are going to get. It specifically states who gets what. So it shows the full picture. Okay. Now, think logically. If you draft the liquidation and distribution account, can the master's office, can the beneficiaries, can the creditors, can everyone just accept that what you drafted is 100% correct? No, we cannot, because you could have made a mistake. There can be errors, and it happens. It happens. People draft it incorrectly, or they leave out important information, or they forget to include certain people. So what happens is, after you've done step 4, after you've drafted your liquidation distribution account, you need to give the public access to seeing what you have done, so they can see that you've done the correct thing and everyone's getting the correct amount of money that they are actually owed. That's the point of step 5. So step 5 is you have to do another advertisement. So this is your second advertisement you need to do. This advertisement is now in terms of section 35 of the Deceased Estates Act. So section 35 of the Deceased Estates Act. Again, ladies and gentlemen, this advertisement needs to be placed in the Government Gazette and the local newspaper. The advertisement calls out all interested parties. It tells them that the liquidation and distribution account has been drafted and that it is going to lie open for inspection. It will obviously indicate where people can go and inspect the L&D account. Usually will lie open at the master's office or could lie open at a particular court, but you will give the details of where, if someone wants to go have a look at it, the advert will indicate where they can have a look at it. Importantly, the L&D account must lie open for inspection for 21 consecutive days. The L&D account must lie open for inspection for 21 consecutive days. Now let's understand step 5. Now imagine you are the creditor of a deceased estate. You lodge a claim, you give proof to the executor. Look, the deceased person owes me R500,000. This is why. Okay. I say as executor, cool, I've got it. I'll include you. Now you're hoping that the executor did include you. And you are hoping that the executor allocated the whole 500,000 Rand to you as the creditor. As the beneficiaries of the deceased estate, you are hoping the executor calculated the L&D account correctly. As a creditor, you are hoping the same, because this L&D account shows exactly who's getting what. It works out the whole story. So obviously, people need to be afforded the opportunity to have a look at this L&D account. Your big creditors, they will send their lawyers out to go and have a look that the L&D account was drafted correctly and that they are getting their proper claim. That's the whole point. So this step 5 is the crucial part as executor, because you are now putting your step 4, the L&D account, open for inspection, notifying everyone, there it is, go check that I did the correct thing, in other words. We are hoping that we get through those 21 consecutive days without any objections. What's an objection? That's someone saying you've made a mistake, you've done the L&D account incorrectly, or you haven't allocated the correct amount of money to us as per our claim. That's an objection. Someone calling you out and saying there's an error on here. If you receive an objection, obviously you're going to look at it and one of two things are going to happen. You're either going to agree or you're going to disagree. If you agree, it means it's wrong. If you disagree, then basically you are saying, well, I don't think I've made an error. I think you are wrong, in other words. The moment there's a disagreement, again, the matter will get referred to the master's office, and the master's office must make the final call. The problem you have with an objection, if there's an objection, it means you must go back to step 4, fix your L&D account, and then go back to step 5 and re-advertise in terms of section 35 and wait another 21 consecutive days. I see a twofold issue over there. Firstly, the obvious one is time. I'm now wasting time. Because I had to fix my L&D and have to re-advertise and wait another 21 consecutive days, I'm obviously delaying the process of winding up the deceased estate. But I see a second issue with that as well. This section 29 advert and this section 35 advertisement in the Gazette and the local newspaper, it is obviously not for free, right? The deceased estate must pay for these advertisements. So if you messed up the L&D and you must now re-advertise in terms of section 35 on step 5, are you not damaging the deceased estate financially? Because obviously the deceased estate is paying for all of this. And the master's office might look at it and say, you know what, Mr. or Mrs. Executor, the mistake you made on the L&D is your own fault. You've done it incorrectly. Now you must advertise again, and let's say the advert costs 500 Rand. Now you're diminishing the deceased estate by 500 Rand because of your own negligence of not being able to draft the L&D account or neglecting certain important information. So they might ask you as executor to pay that money out of your own pocket. And that forms part of that security I was telling you about at the get-go. Why the master's office may ask you if you have security, if you're able to pay for any damages, for things like that. So ultimately, we want to get through step 5 with no objections, or let me rather say with no valid objections. If we get through these 21 consecutive days, ladies and gentlemen, we are home free. We can now move on to the 6th and final step. Ladies and gents, you will now distribute the deceased estate in terms of your L&D account. I told you step 4, the L&D account, is where you obviously show who is getting what. So you look at that and you give all the creditors, all the beneficiaries, everyone who's entitled to something from this deceased estate, you pay it to them, or you give them the asset, depending on what they inherited. That is step 6. Distribute the deceased estate. When you are done distributing the deceased estate, the master's office will give you what we call a filing slip. So the master's office will give you a filing slip. That indicates that your job is done. The deceased estate has been successfully distributed, in other words. Ladies and gentlemen, that is the process of winding up a deceased estate. The 6 steps. Let's recap. Step 1, report the deceased estate. And we listed all those documents we needed to give the master's office. It's important you know that, ladies and gents. Step 1 is crucial. List all those documents that we give the master's office, and the master's office will give us a letter of executorship. Step 2, open a deceased estate's bank account. Put all the money of the deceased into that bank account, so it's just under our control as executor. Step 3, figure out who your liabilities are. How do we do this? We do our notice to creditors, Gazette and local newspaper, giving them up to 3 months to lodge their claim against the deceased estate, so we can see who the creditors are. Step 4, draft your liquidation and distribution account. That is the only thing left that we still have to learn, but it takes time. Step 5, next advert, section 35. Indicate to all the interested parties that your L&D account that you drafted is going to lie open for inspection for 21 consecutive days. Hopefully we can get through that without any issues. If we get through it, our last step, distribute the deceased estate, give the creditors what they're entitled to, give the spouse what they're entitled to, give the legatees and the heirs what they are entitled to. We take our cut as well. Remember, we get 3.5% of the total assets of the deceased estate. I will still show you how all of that works. When it comes to the financial aspect of things, it'll become clear once we start learning step 4, which is the drafting of the L&D account. And we then obtain our filing slip to say our job is done. That's in a nutshell, ladies and gents, how we go about winding up a deceased estate. I really think that the steps are uncomplicated. I believe that what could take time is probably step 1, in the sense of getting all the necessary information and documents to report the deceased estate. That could take some time because we're reliant on the family members to provide us with that information. So that might be a bit of a schlep to get all that information together, but once you have it, you get your executorship. Step 2 is quick, step 3 is quick. Step 4 is what makes it complicated, learning how to draft the L&D account. Step 5 is not a problem, you just got to wait those 21 days. And then step 6 is easy, you're just going to distribute the deceased estate. So it's really step 4, drafting of the L&D, that makes it difficult. Now remember what I told you, if the deceased estate is worth less than 250k, it's an 18.3 estate. Then you don't get a letter of executorship, you get a letter of authority. And you can skip step 4, and obviously you can skip step 5 then, because step 5 is advertising step 4. You don't have to do that if you have a letter of authority and the deceased estate is worth less than 250k. That is why lay persons can wind up that deceased estate. But it is very difficult for a lay person to comply with all 6 of these steps. Because, like I said, drafting the L&D account would be a problem for someone who doesn't understand it. You might have certain exceptional people who can figure it out, but in general, it's an issue. Hence, us as professionals are often the executors of the deceased estate. Right. Ladies and gents, I did say that this evening I want to just talk about, or start talking about, the L&D account as well. So we'll get to that. But before we get there, I think let's mix it up a bit this evening. Let's do a bit of questions now. So anyone with any questions, please raise your hand. Okay, so Funda.
Can you hear me?
I've got you.
Yes, thank you. I just want to find out something here when it comes to the appointment of the executor. So, if the person is not appointed in a will, can they be appointed in any other document? That is the first question. And then please kindly remind me again of the documents needed for you to apply at the master's office to be appointed as an executor of an interstate estate. Yeah, interstate. Thank you.
All right, Safunda. So, look, you pass away one of two ways, either with a will or without a will. So, if you passed away with a will, the only way you can be appointed is if the will nominated you as executor. That's the only way. If you pass away without a will, the only way you could be appointed is if the family members of that deceased person approaches you as a lawyer that maybe they know to say, look, we don't have a will. We know we have to wind up the deceased estate. We don't know how. Can you please help us? And then you get a next of kin affidavit from them, an affidavit whereby the close family members appoint you as executor. So it's only one of those two ways, really, either through the will or through the close family members appointing you. As for the second part of your question, you asked what are the documents needed to report the deceased estate to the master's office. Just to quickly recap, there was 3 standard documents. We called it the death notice. Secondly, we said the inventory. Thirdly, we said the document, it's called acceptance of trust as executor. So 5 words: acceptance of trust as executor. Then we said outside of those 3 documents, there's also other information we need to give the master's office. We said we need to give the master's office the death certificate of the deceased. If the person died testate, we need to give the master's office the original will. If they died intestate, we need to supplement this will in some other way. That's where those 2 affidavits come in. The first one being the nomination affidavit, that obviously appoints you as executor by the close family members. And the second one being the next of kin affidavit. The next of kin affidavit is where you specify in terms of the rules of intestate law that we learned on Monday, who are the rightful beneficiaries of the intestate deceased estate. Other than that, we also mentioned that the marriage regime of the deceased is very vital. So we have to give the master's office proof of any marital documents, whether it's marriage certificates or antenuptial contracts or customary law affidavits or whatever it is. We have to give the master's office proof of the type of marriage. And we said we also need to give the master's office proof of who all the beneficiaries are. So whether it's ID copies of the beneficiaries, or if the beneficiaries are the kids of the deceased, we can give them the birth certificates. Yeah, and that was in a nutshell what we discussed, Safunda.
Thank you so much. I'm clarified.
Perfect. All right. Oba King, Sabanda.
Yes, how are you?
Good, and you?
I'm good. I just want to find out with regards to the appointment of the executor. Especially when the estate is not in terms of section 18.3, where the amount of the estate exceeds 250,000. Who actually is qualified to be appointed as an executor? Because I heard that you've mentioned that a layperson it will be difficult for them to actually wind up that estate. Yes, number two, just to question 2 is, can the executor also be a beneficiary of the deceased estate? Thank you.
Okay, perfect. So your first question, look, anyone can be an executor. You are not restricted in terms of who you appoint. I mean, you can nominate your spouse or anyone, you know, to be an executor of a deceased estate. The only problem, like I say, is they are going to have difficulties in winding it up. So that is why it's recommended that you go to a professional person who knows how to do this, like a lawyer. Even some chartered accountants can do it. And banks obviously do it as well because they have their own legal team that deals with these type of things. So you're not restricted in terms of your appointments. However, I can assure you there's going to be troubles if for that executor in winding up that deceased estate, as they won't know how to do all of these things. That's just what, you know, sort of history has shown me. Second part of your question. Now, don't mock me, but I think I've already forgotten that second part of your question. If you can just remind me, sorry, Obakeng, and just for future, ladies and gents, if we have more than one question, can we go one question, then I'll answer, second question, then I'll answer, and so forth? Otherwise, I forget all these things. If you can just remind me of the second part of your question.
No, it's fine. I just wanted to find out whether the executor can also be the beneficiary of the deceased estate.
Ah, yes. Okay. Interesting question, actually. So, an executor can be the beneficiary of a deceased estate. The problem you have is what we learned is if you draft someone's will or if you sign as a witness, then you are disqualified from inheriting unless you can prove certain things in court, blah, blah, blah. Now, to be nominated as executor, no problem. You didn't draft the will, you didn't sign as a witness, you just nominated as executor. No issue whatsoever, you can benefit. The problem comes in, Obakeng, is what happens if, let's say, your father comes to you and says, you know, Obakeng, please do my will for me, please draft my will for me, you can be executor of the deceased estate. So you go and you draft your will for your father, but he appoints you as a beneficiary in his will. Do you see how you have a problem then? Because now you're the executor, but you also drafted the will, and now you're sort of disqualified from inheriting. So there is a way around it. If you are the executor, but you also drafted the will, and you are also the beneficiary, then you need to explicitly state in the will that I, as testator, am aware that the author and drafter of the will, Obakeng Sobanda, is my son, and I grant him, you know, authority to still inherit from this will, even though he drafted the will, and he should not be disqualified from inheriting. So remember I said you can change common law in your will, so then you would need to expressly state as the testator that you are aware that the drafter of this will is also a beneficiary and that they should not be disqualified from inheriting. Then you're okay. But if you don't state that, then you could have an issue because you drafted the will. So to answer your question straight, no problem, you can be executor. Just be careful if you're also the drafter of the will, that could cause problems.
I understand. So it means that the drafter of the will doesn't need to be an executor, and an executor doesn't need to be the drafter of the will. It can be either or.
100%.
No, thank you.
Perfect. All right. Ladies and gents, next hand, Molema. Mogoro.
Good afternoon, colleagues, or good evening. Okay, my question is regarding marriage, since marriage plays an important part in estates. My understanding is that if you are married out of community of property and you don't specify that it's without accrual, the default is that it is with accrual. Am I correct?
No, so how it works is if you just have a marriage certificate, then you are married automatically in community of property. If you have an anti-nuptial contract, then you are out of community of property. And an anti-nuptial contract, for it to be valid, must specify whether you are with or without accrual. So the anti-nuptial contract will always specify with or without accrual. Otherwise, it's not valid.
Okay. Thank you.
Are you covered, Malema?
Yes, thank you. Thank you.
Perfect. All right. Warwick Mitchell.
Hi, just first question. At what stage in the process of winding up the estate would you need to obtain a SARS tax compliance certificate?
So that would be when you are busy with your estate duty account. That will need to be completed. So you would need to sort that out around step 4 when you do your liquidation distribution account.
Okay, perfect, understood. And then the second question is, are the heirs and legatees entitled to request and view the documents directly from the executor?
They are entitled to do so. You know, you have a couple scenarios, or I've had a couple people come to me and say that certain attorneys are executors of deceased estates, and it sounds like that they're not being included, and they ask the attorneys, you know, just so that they can review the documents, and the attorneys don't give it to them. Then they end up reporting that attorneys to the master's office, and it becomes a bit of a mess. So the practice is, if you have an interest in the deceased estate, so if you are a beneficiary of the deceased estate, whether by testate or intestate law, they should be allowed to review the documents. Obviously, if you are not a beneficiary or an interested party, then the attorney is not obligated to allow them to review the documents.
Perfect, understood. Thank you.
Perfect. Right. Next one, I see Richard.
Hello.
Hi, Richard.
Yes. I have only one question. I would like to know. Let's say I'm busy winding up an estate. So there is a property that I must sell, and this property takes forever to be sold. You see. So I would like to know what will happen there. Will I be able to move to the next stage, or I must just wait for that property to be sold up until I get a buyer? Yeah, my question is that one.
Yeah, Richard, you see, that happens now. I think I mentioned somewhere during the week, I can't remember when, probably last night, that, you know, you have some people that's taking 10 years to wind up a deceased estate, where ideally you want to do it in under a year. So look, what happens is, what recommendation is given from the master's office, or what is actually technically required, is that you are done with step 4 by within 6 months after you obtain your letter of executorship. So you obtain your letter of executorship, you must then complete step 2, step 3, and step 4 within 6 months. If it takes longer than that, then you need permission from the master's office. Now, if you needed to sell an immovable property, you would not have been able to complete your step 4 if you're still waiting for that property to be sold. So you're going to be later than those 6 months given to you, and you're going to have to notify the master's office. And this does happen. This happens more often than not, and more often than it should. But it does happen that you are unable to sell a property. And if something like that happens, you need to play open cards with the beneficiaries and the creditors and explain to everyone, look, we can't wind up this deceased estate until we have this property sold. It might reach a stage where you sell the property at a lower price than what you were hoping for, below market value. It might reach a stage where you maybe put the property up for auction, you know, with perhaps a reserve price involved. But ultimately, you cannot wind up the deceased estate without that property being sold, if the objective is the property needs to be sold to wind up the deceased estate. And there's not much you can do. You have to wait and aggressively advertise it. and try and make a plan to maybe sell it at a better price, perhaps. But that's, your hands are tied in that regard. You know, normally properties get passed on to someone, so you don't have that problem. But if the instruction is to sell, then unfortunately you have to wait until it's sold, and you'll just need to notify the master's office about the delay, so they don't think you're not doing your job, and they understand why there's a delay in the process.
Okay, thank you so much. Thank you so much.
Cool, Richard. All right, Cabello.
Hello.
Cabello, you're very soft. I think I can just hear you.
Can you hear me now?
Yeah, got you.
Yes, I wanted to ask, in the instance where the creditor's claim exceeds what is in the estate account, is your 3.5% and the master's fee affected by that?
Good question. So, ladies and gents, just for those who are unsure from the basis from the question, after step 3, you would have established your assets and your liabilities. Now, we can think for ourselves that it might happen in certain instances that liabilities might exceed the assets. Now, what happens if that happens? You have an insolvent deceased estate. That's a problem. How you would approach this in practice is you would have to notify the preferential creditors. That will be like the banks, the municipalities, generally the creditors that you owe the most money to, or that the deceased estate owes the most money to, and ask them how you should handle the process going forward. Usually one of two things can only happen. They're either going to tell you just carry on winding up the deceased estate, we'll take less money, or they're going to tell you to switch over to insolvency law, and an insolvency law process has to be followed. Now, to come to the question that was just asked, you as the executor and the master from the master's office, the advertising cost that was done, all these type of things, and I'll obviously go into depth with that tomorrow, you are regarded as an administrative creditor. You need to be paid. So you are, all administrative creditors are going to be paid, so you will get your money. The other creditors that we'll be looking at tomorrow, they obviously might be in a bit of trouble and might be able to only take certain cents in the rand, you know, whatever insolvency law is allowing them to take. So you would still be okay at the end of the day.
I'm verified.
Cool. Right. Mtolo, M-T-O-L-O, Mtolo. Am I saying that correct?
Yes, thank you, sir. My question is, let's say I'm married out of community of property without accrual, and I don't have a will, and I don't have a child. I die before I have a child, and I leave behind my sisters and my brothers, as well as my husband. Who will inherit in that case? Because I don't have a child and I don't have parents. Thank you.
So that you died without a will, so you died intestate.
Yes, sir.
Yeah, so that would be step 1. Rule 1 says husband and kids, spouse and kids get everything. So you have no kids, so your spouse would just take everything.
Even if I'm married out of community of property without accrual?
Correct, yes. So remember, when you wind up a deceased estate, you first look at marriage. Now, if you were married out of community of property without accrual, it would mean your husband has no claim against your estate due to the marriage, right?
Yes.
However, thereafter, we now look at intestate law, and you go through the steps, step 1, 2, 3, 4, 5. So you start at step 1. Step 1 says if you have a spouse and if you have kids, they take everything. Now you have a spouse. Doesn't matter if you're in or out of community of property, you are still a spouse. And your husband, in that case scenario you gave me, would be your spouse, and he would have taken everything.
Okay. But if I have a will, then the will apply.
Correct. Then we won't worry about those 5 steps. Then we'll just look what your will says.
Okay, thank you so much.
Perfect. Lion, I remember you had a question last night.
Trial.
Hello.
If you're referring to me, Lwazi.
Trial.
Lwazi, you can go. I'm not getting anyone else. You can go, Lwazi.
Okay, yes. My question is regarding the payout of pension funds and provident fund. I'm not sure if you're still going to cover that.
Trial.
I just wanted to find out that if my understanding, you have a nomination form as to who you get what from your payout. Let's say if I nominate my parents, that they get 100% of the payout. Now, I've just recently learned that the trustees don't necessarily have to just follow what my instruction is on the nomination form. They have to go and investigate first as to if I've got other people that are responsible to me before they do the payout. I just wanted to confirm if that's correct, or the nomination, as I've stated, will be paid out to the people that I said they will receive the money.
Lwazi, that's a very controversial part of the law currently at the moment. So the understanding is who you nominated in your pension fund or retirement annuity, they need to receive the money. But what has happened over the last couple of years in certain isolated events, and I stress this is not the norm, it has just happened in isolated events. We have had pension funds not paying out the nominated beneficiaries, but paying out who they believe should take the money from the deceased estate, which is contrary to the nomination that the deceased actually made when they took the pension fund out. And, you know, they claim that it's due to their certain pension fund rules. They're allowed to do this and they're allowed to apply their discretion. I do know these things are being challenged by court, because it is also unethical for you to take out a pension fund and say, Carl must get R1 million, or Carl must get your pension fund if you die. And then if you die, then they pay out John instead of Carl, for argument's sake, because that's also against your own wishes. But this has been done in isolated events. I know it is being challenged in court. So it could happen, to answer your question, because it has happened in the past, but it is not the norm, if I can put it that way.
Okay, thanks.
Cool. Right.
Ekitemba Twala.
Ekitemba, you are next. Go for it.
My question is, certain persons are disqualified from being appointed as executors. So who are these people? I think there was a guy who asked, I think it was, I'm not sure whether it was about the will or it was about the estate. So I did not get the information while there. So maybe you can repeat that for me, please. Who are the people who can be disqualified from being appointed as executors?
Trial.
Sorry, Becky, before I answer you, there's some weird sound coming in the background from someone.
Trial.
There it was again. I'm not too sure who that is.
I can hear that also.
Yeah. So, yeah, I don't know what's going on there. So just check that out on everyone's side, ladies and gents. It's almost, I don't know. I can't hear what they're saying. Almost sounds like they're calling my name. But yeah, just check it on your guys' side. Right.
And Lions, Mike, Lion.
Lion, Lion.
Yes, it's Lion Mapunye.
Okay,
That's
Lion,
good.
I will be with you after I've sorted Becky's question out.
There he is again.
Right. Becky, you asked, if I recall, you asked who could be disqualified as being an executor of a deceased estate.
That's correct.
In a nutshell, well, to be honest with you, the only way you can be disqualified from a legal perspective to be an executor would be if you have a criminal record that involves fraudulent and money type of related crimes like theft, fraud, money laundering, etc. You can then be disqualified for being an executor. Also, if you are liquidated or what's the word I'm looking for, sequestrated. You can also be disqualified for being an executor. And then thirdly, if you played any part in the death of the deceased, let's say you murdered the deceased or something along those lines, you would be disqualified from being an executor. So it's about your insolvency, whether you murdered the deceased or whether you have a criminal record that relates to some other financial crime. You would be automatically disqualified from being an executor. What I was speaking to earlier about, because I believe another gentleman asked that question, we were just saying that you can be an executor of a deceased estate and you can also be a beneficiary of a deceased estate. No problem. However, just make sure you are not the drafter of the will. Often executors draft the will for someone. So if you draft a will for someone, then make sure that you are not a beneficiary to that particular will. Does that cover you?
Okay, cool. No, thanks, Mr. Kisman. Thank you
Cool.
very much.
All right, Lion.
Well, it's nowhere to be found. Can I just ask a question, Mr. Kisman?
Is Lion gone?
No, it's not Lion, it's Sinatra.
Yeah, let Lion go first. Lion was trying to ask a question yesterday already. Sinatra, I'll come to you after Lion.
All right.
Trial?
Yes, go for it. I'm listening.
Trial?
Lion, there's a definite
trial
issue on your side. It's coming, weird words are coming through. I don't quite understand it. I don't know if there's a delay on your end or if there's a computer error. Perhaps maybe log off Lion and then log back on, because we're not hearing you clearly. It's just one word that just keeps coming out repeatedly. So perhaps mute yourself, Lion, log off, log back on, and raise your hand, then I'll come back to you. Sinatra, I think proceed.
Yeah, I just want to find out regarding the bank account that the executor has to open. Is it a normal bank account or a trust account?
It's a normal bank account, but it's a deceased estate's bank account. But it's not a trust, it's just a normal one.
All right. No, that's thanks.
Yep. Aisha. Aisha, are you not with us? Okay.
I am here. I am sorry.
Okay. No problem. You can proceed with your question.
I have a question here. Okay. In an L&D account, okay, you're preparing the L&D account. The pension fund and the annuity funds, you need to add it in your L&D account, even though there has been beneficiaries appointed in that account.
No, you will exclude it from the L&D account because the L&D deals with the deceased estate and the pension funds and annuities are excluded from the deceased estate.
Okay, because I see we had a question on that one that you sent us I don't know, that you sent us those notes. There was a pension fund and then I see it was listed in the L&D in the answers.
Yeah, well, we'll come to that, and there may be an exception in certain instances, but as a general rule, it's not does not form a problem.
Sorry, I just have another question, please.
Go for it.
1 second. I just made notes here. Okay, let me get it. Okay, so can you have more than one executor?
So the general idea is only one person is in charge of winding up your deceased estate. You could, for example, let's say you were appointed as executor. Now you're entitled to 3.5%. You're doing the whole process. You get to step 4 and you think, goodness, I'm struggling with this liquidation and distribution account. I maybe want to go to Carl for argument's sake for assistance. So you come to me to assist you with winding up the deceased estate. And then perhaps we reach an agreement that you only take 2.5% and I'll take 1% for argument's sake. So someone could assist you and then you share in your profits, but there's one appointed executor.
Okay. The next question, if you reach a stalemate in the nominations of executors by next of kins, then what you do?
So I didn't quite catch that, Aisha, if you can repeat that.
If you're unable to nominate the executor by, like the next of kins are unable to decide who to nominate as an executor, what you do?
Then, look, if you've been if someone's appointing you but others don't agree, you need to get an affidavit from that person. You need to notify the master's office. This is the issue. You know, this one's appointing me. This one has a problem, and the master's office will give a clear direction of what needs to happen. What would happen is they'll either accept your appointment, or the master's office will go and appoint someone of their own, a totally different person that no one knows about, someone they just go and appoint randomly to solve the issue.
Oh, okay. Sorry, my next question. If you're drafting a will, okay, must the will be commissioned, or does it only get commissioned when the testator makes a mark or use someone else to draft the will? Must the will be commissioned?
By law, it only needs to be commissioned if someone else signs the will on behalf of the testator. But what you often find is a lot of attorneys go and commission the will. And the reason for doing it is we sometimes have a problem of getting the original will. So you give the original will back to your client, for argument's sake, and you have a copy at your office. Now, sometimes no one can find that original will of the client, and it becomes a problem. So you'll often see they commission it and certify it as true, well, commission it specifically, just so that if the original can't be found, they have a backup.
Okay, I just have one more question, two more questions. My second last question: the power, if you're going to hand over power attorney to a attorney, you're going to sign a power attorney and let the attorney handle the winding up of the estate. Do that power attorney need to be approved by the master?
No, it doesn't need to be approved, but the master does have the final say. So if someone's appointed you in that line, you remember you need to still get the master to give the final approval. So you would be approved unless, of course, the master believes you have a criminal record or, you know, are insolvent or played a part in the death of the person. So that, and also remember one thing, the master could also override your decision if the master requests you to give security before you act as executor and you are unable to give security. But if you can give them that security and you have no issues, as we mentioned previously, then the master's office will always accept your appointment.
Yes, because if you're going to give a power attorney to an attorney to wind up the estate, then you're going to have to pay the attorney. Where does that money come from?
Well, here's the thing. A power of attorney to wind up a deceased estate is given from who to who? Are you saying from the deceased person before they passed away or from their family members?
No, from the executor. The executor, he's now a layman person. He can't wind it up. He signs over power attorney to a professional to wind up, an attorney to wind up the estate. The executor signs over power attorney to an attorney.
Okay. And then remember, your payment and all the monies must come from the deceased estate. So you will then need to seize control of that deceased estate as such. So,
Oh, okay.
So you
so
get
the person you
would be entitled to that 3.5%, in other words.
Oh, okay. Because you're signing power attorney to a attorney to wind up the estate. So does the power that person that you sign the power of attorney to, does that person also need to be an executor or what?
Yeah, that information must be passed over to the master's office so they are approved as executor of the deceased estate.
Okay, my last question, sorry. How does a minor inherit in terms of interstate and estate? How do they inherit? I mean, like, how do they get their money? Obviously, say minors can't inherit. So they will inherit most probably when they become majors, but where do you keep the money so long till they become a major?
So that was that testamentary trust that we spoke about that needs to be opened. And
I see.
The trustees will look after that money until they've reached majority.
Okay, I see. So in the meantime, they can take care of them with that money till they reach majority to handle their own affairs.
Correct, correct.
Okay, thank you so much. Appreciate it much.
Cool beans. All right, Connie, see your hand's been up for a while.
Mine, I'm checking, is there a time frame within which the deceased estate must be wound up and distributed? Basically, can it stay forever and ever? In this case, two spouses passed away. Actually, the first spouse passed away. The letter of authority was obtained by the second spouse because the first spouse died interstate. Then the second spouse held that letter of authority forever since 1996. She also passed away. Then now the grandchildren have been nominated in the letter of authority, but they also do not want to wind up the deceased estates because they are afraid, they don't want the house to be sold. But the question is, can it stay forever and ever in the name of the deceased, the property? In this case, it's a house, and there are cars also. So is there a time frame within which the estate must be wound up, and does the letter of authority expire?
Yeah, that's a difficult situation, Connie, and I'll tell you why. So this is a worst type of thing that can happen because what you end up having is property that's actually not owned by anyone. You have someone claiming to own the property, but if you look at the title deed, it belongs to someone else. And then this has a knock-on effect over the generations to come. And you have all kind of land that's unclaimed and unowned. So it's a huge problem. So in terms of your question, there's no time frame. You can now go and report to the master's office and say, look, this and this is what's happened. This is the position. These people have the letter of authority. They are not acting on it. We need the master's office to intervene and grant someone a letter of authority or a different person to take control and seize this deceased estate. So even if it's 20 years later, for argument's sake, and this problem is still persisting by the sounds of what you were saying, you can intervene, write to the master's office, explain the story, give details of the deceased person, etc., and allow the master's office to then appoint someone that they think is most suitable for the position to seize control over that deceased estate. And then the process can then follow thereafter.
All right, thank you, sir.
All right, Connie.
And lastly, sorry, I just said thank you, and then I realized I have one last question. What happens if the current beneficiaries, beneficiaries in the letter of authority also passes away?
So remember, they would have passed away then after the death of the initial person. So then one will has to look at those beneficiaries. Who are the beneficiaries of their deceased estate? So if I'm X and I leave something to John and I die, John obviously receives the inheritance from me. If John then dies, then we'll have to look at John's will to see who's next in line, or if John dies intestate, follow intestate rules. So we look at testate or intestate law of that beneficiary then to see, because remember, if you died after the first person, it means you've already claimed your inheritance. So that inheritance is passed over to the deceased beneficiary, and we'll look at the deceased beneficiary's will or the intestate law to see how that now needs to be passed.
Thank you, sir.
Perfect, Connie. Before we go further, I just want to hear, Lion, are you back yet? Does not seem that way. All right. Lena Mile.
Trial.
Good evening, sir, and good evening to everyone. Sir, I just want to ask one question. The letter of executorship or letter of authority, is it limited to those assets that are listed in the inventory, or what happens to those assets that you realize after submitting that list and receiving the letter?
Yes, that happens sometimes then, Amile. The rules is, that's been set forth is if you discover assets after you've done the inventory, which can happen sometimes, you just need to notify the Master's Office, report to them, explain to them what assets have been discovered after the time, explain why you only discovered it now and not before the time, and also indicate to the Master's Office what is the value of those assets that has been discovered after you've done your inventory. And then obviously that asset also needs to be included when you distribute your deceased estate.
Okay, thank you.
All right, perfect. Khotatso Pakati.
Yes, hi, sir.
Hi.
Yeah, I just wanted to ask two questions. The first one is selling the immovable property in a deceased estate. What happens if the property is being transferred or is sold before the master's consent is obtained? What's happening there? Can you sell that property without obtaining the master's consent?
The thing is, you wouldn't be able to, because what does selling a property involve? It involves registering the property in the deeds office to a new owner. And the only way you can do that is with the signature of the owner of the property. Now, if they've deceased, how are they gonna sign off? So how would they sign that?
So what happens if that property has already been advertised? The purchaser was informed that they should pay transferring costs as well as bond costs, whereas the master's consent was never obtained. Now the purchaser is being informed that we're still trying to find we still haven't obtained the master's consent yet. And I checked it. I think it's in terms of section 42. I'm not sure. But I just wanted to find out what that purchaser is supposed to do if something like that.
So the starting point for that is there an offer to purchase, a written sale agreement, and has that sale agreement been signed between the seller and the purchaser?
Yes.
So that was done whilst the deceased was still alive, correct?
No, the purchaser didn't even know that the property being sold is from a deceased estate, and the consent is not obtained yet. And I think the purchaser advised that they had been there since September 2021. They were informed that usually transfer takes up 3 to 4 months, and now it's 2023 and the purchase is still there. So I was asked that question last week, what that purchaser should do.
Okay. Well, I have two answers for you. Answer one is that sale of the property is fraudulent, it is unlawful, it is invalid. All right. You cannot enter into any lawful sale agreement without a written contract as your basis. Unfortunately, people do word of mouth because they don't know better, but those type of things don't hold up. So what happens in such a scenario if the purchaser has paid money and expenditure in this regard already? They are entitled to restitution and may claim to have their money paid back to them. That is the hard and fast law on this. The sale cannot push through. My second answer is, however, one has to also go look at who are the beneficiaries to that house. Let's say beneficiaries are John and Sue. And John and Sue are the ones who tried to sell this property to the purchaser. Then John and Sue can request consent. They need to appoint an executor, and the executor can request the necessary consent, and the executor can then authorize the sale of this house to whoever that purchaser was. But only if it's consented to by all the beneficiaries to that immovable property who would have received that property. Then a plan can still be made for the sale to be valid.
Okay,
But what happens to the purchaser now? Because when they moved in, they started paying rent and they are settling the municipality.
So Kofatso, you just broke away there. What I've got from your question was what happens to the purchase because they've already started paying rent and settling municipality bills. Like I say,
yes, that house is still not transferred.
Like I say, those purchasers have no lawful claim to ownership over that immovable property.
I'm listening, sorry.
However, they may sue for losses and damages being incurred from these people who fraudulently sold them the property. So they will have a civil claim in that respect. But unless agreed to by all beneficiaries, they have no rightful claim to ownership over the immovable property. Because when can you have ownership over immovable property? Only when you obtain a personal right to the property. How do you obtain a personal right to the property? Written sale agreement that specifies seller's name, purchaser's name, specifies the correct description of the property, specifies how much the property is being sold for, and is properly signed by both seller and purchaser. Then the purchaser has a claim to that property. But in your case scenario, you said there was no such thing. So the purchaser will never ever be able to on their own enforce the sale of that immovable property. They are not authorized to, and there's no law that supports them. The only thing they could do is to sue for any damages that incurred as a result of the fraudulent sale of the property. But that is also extremely dodgy and difficult because the purchaser has also acted unreasonably by moving into a property without the seller selling the property to them. You know, no reasonable person would just move into a property without getting the necessary documents in order, and that's how the courts look at it. So that might also be an issue. But if they can show the fraudulence on the part of the sellers and show that they were, how can I put it, misrepresented into entering into the property, then they could have that claim for damages. But as far as ownership to the property goes, they don't have any rights towards it because the sale agreement was never put in place.
Oh, so in other words, they should first look if, oh, okay, this is too much information for me, but I have that second question in terms of interstate succession, especially with the part where if you are predeceased and the children inherit of the predeceased child. So what happens if you have no that predeceased child had no children but had a spouse? Does it still go to your spouse that you left behind, or that predeceased child's spouse? Phew, that's a mouth.
Okay, so the rules is if you are predeceased in interstate law, it means your kids can obviously step into your shoes and inherit. If you don't have kids but you have a spouse, your spouse is not entitled to anything. So the spouse of the predeceased person does not have a claim, only the kids of that predeceased person. So if you have no kids but you have a spouse, it's irrelevant. The spouse cannot receive that claim. That amount will just fall back into the deceased estate and be distributed amongst the other kids.
Thank you so much.
Perfect. Ladies and gents, I think we're going to take a little break. Can feel my voice is starting to go a little haywire over here. I see it is now 20 past 7. Let's take a 10-minute break and then we will continue at 7:30. Catch you all in 10 minutes. Right, ladies and gentlemen, it is 7:30 on the dot. I think we need to progress a little bit with some work. I want us to start looking at the liquidation and distribution account. Let's get a couple important things out the way. I want us to just sort of have an understanding this evening of what we're trying to achieve, because the concept would be me talking about these different accounts so we get to understand the purpose thereof. Thereafter, we look at how that account is drafted, primarily tomorrow evening. Thereafter, on Friday evening, we go through an exam type of question together so we can start to put figures with things as well. And I can tell you right now, already, ladies and gents, from doing this for a number of years, it's a process. You are not going to necessarily after tonight and tomorrow night know what's going on 100% with these accounts. You're still going to have questions, you're still going to feel confused, and I dare say overwhelmed at certain instances. But by the time we get to the end of Friday evening, everything starts coming together and it starts to make a lot more sense, and you will definitely be in a position where together with the notes I have provided you with, and together with the notes you are taking down while I'm lecturing, you would be able to study this L&D account because you would understand the purpose of everything. And I'm also going to show you how to answer certain questions. You could study certain things like a parrot, I suppose, but I never think that helps anyone. I mean, you don't make a future about studying things like a parrot. You make a future about understanding the logic and practicality behind it. And that's what I want to try and display to you tomorrow evening and Friday evening, so that we have that basis and we are sort of at a standpoint where we can go and study the L&D account because we understand what we're trying to achieve. Now, I mentioned to you that there are about 6 different accounts we've got to learn. I mean, if I ask you to draft a liquidation and distribution account, I'm effectively asking you to draft 6 different accounts, for exam purposes. So please don't think it means you must just draft a liquidation account and just a distribution account. No, a liquidation distribution account consists of a number of different accounts. Now, before we even start looking at the notes, I want to just speak to you about those different accounts, and you can take notes. It would be probably to your advantage. And the idea about speaking about these different accounts is that when we start to look how to draft it, you already have a basic understanding of what we're trying to achieve in each account. And you will see each account is so necessary. Each account serves its own unique purpose, and you'll actually see the accounts rely on one another. You can't do the one account without figures and answers from the other account. That's the idea behind the L&D account. So let's just have a quick chat about these different accounts that we want to speak about, or that we have to learn rather. So the first account would be what we call the liquidation account. That is how you start drafting your L&D account. You must start with the liquidation account. Okay. Why? What is this liquidation account? Ladies and gents, this is your main account. It is your biggest account. It takes the longest to draft. It takes the longest to learn, I would say. But it is also the account that you are going to make the most easy marks with in an exam, right? Because once you've studied it, and you'll see by the end of Friday, it will make a whole lot more sense, because we start to reach a point where we start repeating ourselves. And that's when things become easier and clearer to understand. But that'll happen as the week progresses. But the idea behind this account is the following. You list all of your total assets in this liquidation account. So remember, in step 1, when we did our inventory, we already figured out what the assets are. You've got to list all the assets in the liquidation account. You've got to list it and put the value next to each asset. We want to know, what is the total value of all the assets in the deceased estate? I mean, you could have a house, you could have a car, you could have furniture, you could have shares in a company, you could have 50 grand in your bank account. Whatever assets you have, we're going to list it and put down the value of that asset. You know, we divide assets into 3 categories. We have immovable property, movable property, and claims in favor. Now, I think immovable property speaks for itself. That's your house. Hey, if you don't have a house, you don't have immovable property. But if you own any property, it's regarded as immovable property. Your second category is movable assets. Ladies and gents, what is movable assets? Your car, your furniture in your house, your firearms. Whatever asset you own that can be moved is obviously movable property. Interestingly enough, any shares that you own in a company is regarded as movable property. If we break it down, it actually makes sense, because if you own 10 shares in company ABC, what do you own? You have a share certificate, right? That's what you have. You have a piece of paper that says you have 10 shares in this company and it's worth X amount. That's what shares in a company is. Can you take that piece of paper and carry it around? Of course you can. It's a share certificate. Hence, shares in any company falls under movable assets. You know, I mentioned that specifically because it is the one type of movable asset that you might need to think about. Is this a movable asset? What type of asset is this? Shares in a company is regarded as a movable asset. All right? The third type of asset you have is what we call claims in favor. Easy way to remember claims in favor, that is money. Any money that the deceased has or money that's going to be paid out into the deceased estate, that falls under the heading claims in favor. That's the easiest way to remember it. 2 examples or main examples to look at there would obviously be money in a bank account. That would be a claim in favor. Or any policies that pay out. I mean, I mentioned to you earlier in the week already that policies is a funny thing, because some policies get paid into the deceased estate and some don't. I think the natural life of a policy is that it does not get paid into a person's deceased estate. But there may be instances where it does get paid into a deceased estate. Rare, but it can happen. You know, writing a wills and estates exam is like almost learning how to pass a driver's license test. You know, the way they want you to drive there, I don't think anyone drives like that afterwards. And that's pretty much the concept. You learn it the tough way so that it becomes easier to do when you do it in practice. And I would venture to say, writing a wills and estates exam or doing an L&D in an exam is much more difficult than doing it in real life, because you're seeing things for the first time. Where in reality, before you even start your L&D account, you already know what assets there is, you already know what liabilities there is, you have all the information in your mind before you even start drafting it. Where when you do it in an exam, you're seeing it for the first time. And that's what's intimidating about it. But nevertheless, we said the liquidation account is your first account. And you started off by listing all the assets in the deceased estate, right? Immovable property, movable property, and claims in favor. You add it all up, and that's going to give you your total assets in the deceased estate. Another word for total assets could perhaps be the gross value of your deceased estate, right? But the idea behind the liquidation account is we want to figure out what is the net value of your deceased estate. So how do we figure out that? I mean, if you think of your pay slips, what's the gross value? It's your salary, right? What's the net value? It's your salary minus tax, minus UIF. Depending on what type of employment you are, they might minus your pension, they might minus medical aid, blah, blah, blah. Whatever gets paid out is your net value. Now it's a similar concept. To figure out the net value of a deceased estate, we must go assets minus something, right? Now there's 2 things that get minused from your assets, okay? The first one is obvious, your liabilities. So from your total asset value, we now need to minus the liabilities of the deceased estate. What's another word for liabilities? Ladies and gents, creditors. Remember step 3, we had to establish who are the creditors of the deceased estate. Why are we minusing creditors first? Because remember I told you creditors are ranked number 1. They're the first people who has a claim to a deceased estate. So we need to minus their claims from the total assets to figure out what's left. in other words. So we now minus our liabilities. You will see, I've put this all down on pen and paper for all of you. We will work through it tomorrow evening. I'm just trying to make sure we sort of have an understanding before we get to it. You get two different types of liabilities. You get administrative liabilities and you get creditors. Okay, so you get admin expenses or administration expenses and you get creditors. Now, let's understand the difference between the two. An administration or admin expense. This is the natural expenses incurred when winding up a deceased estate. I'm going to say this again. This is the natural expenses incurred when winding up a deceased estate. Let's think logically about it. Anyone who dies and whose a deceased estate gets wound up has certain liabilities that cannot be avoided. Let's think of the 6 steps we learn in winding up a deceased estate. You would have seen that there was 2 adverts, right? The Section 29 advert and the Section 35 advert. Are those adverts for free? No. The deceased estate must pay for it. So it's a natural expense. For me to wind up the deceased estate, the deceased estate naturally has to pay these advertising costs. The deceased estate owes me as the executor 3.5% of the total assets of the deceased estate. That's a natural expense. I'm a natural creditor to the deceased estate. The deceased estate owes the master money. That's a natural expense. Step 2, did we not have to go and open a deceased estate bank account? We did. Now, what does every bank account have? It has bank charges. That's a natural expense. The deceased estate must pay for it. If we had immovable property, you would agree that immovable property will now need to be transferred into the beneficiaries' names. So there's transfer costs, conveyancing costs. The deceased estate must pay for the transfer into the beneficiary's name. Again, it's a natural expense. You can't avoid it. Another example would be when you listed your assets and you listed that house and you said the house is valued at 2 million rand. Could you thumbsuck that 2 million rand? No, you weren't allowed to, right? That car, that Toyota that was there, that you said is valued at 150K. Could you thumbsuck that price? No, you couldn't. You had to go to someone and that person had to give you a valuation on your property. Now, ladies and gents, do people do that for free? No, the deceased estate pays for those valuation costs. So whoever valued the value of your assets, the deceased estate had to pay for them. So those valuation costs are a natural expense. So do you catch my drift? Admin expenses, every deceased estate has them. Obviously, some deceased estates have more than others. I mean, some people might not have a house. So there's no conveyancing costs involved over there. You know, so some might have more than others. But the point is, every estate has natural expenses when winding it up. So that is your first creditor, the admin expense. Someone asked earlier, if the deceased estate is insolvent, do you as executor still get your money? I think it makes a bit more sense now when I say you are part of that first group of creditors who get their claim against the deceased estate because you're an admin expense. We said there's a second type of liability. That is your creditors. Ladies and gents, who are your creditors? Remember step 3 when we did our section 29 advert and everyone had to lay their claim and prove that the deceased estate owes them money? All those people who prove their claim, who prove that they are creditors against the deceased estate, they need to be listed under the heading creditors. Ladies and gents, that is your liabilities. Your liabilities is your admin expenses and all of the creditors of the deceased estate. So now you go and you add all your liabilities up. If you look at your liquidation as a liquidation account as a whole now, what does it read? It reads total assets minus total liabilities. There is one other aspect that needs to be minused. We call that aspect estate duty. Now, ladies and gents, I'm going to ask you to open a note now. Now, we're going to be learning this note tomorrow night, but for purpose of me explaining it now, it's going to make much more sense. There's a note that was sent to you. It was called L&D. If you open it, you will see it's my handwritten notes, and it's 10 pages. I think the first page starts with the heading Tips with Liquidation Account. I'm going to give you a minute to quickly open that notes that I sent. And again, we'll be analyzing these notes tomorrow night, but it's just going to help for my explanation now already. So you have a minute. Please open the L&D notes, 10-page document, handwritten notes. Right. Just on those notes, just swing over to page 2. Just to illustrate what I was talking to you about. Remember I said you start off with a liquidation account. You can see I started with assets there. Don't worry about the content. We'll go through it tomorrow. But just to illustrate, you can see under assets, I have the heading immovable property. If you scroll further down, you see I have the heading movable property. If you scroll down to the next page and the page thereafter, if you go to page 4, you'll see I'm finished listing all my movable property. On page 4, I have my claims in favor. Remember I told you 3 different types of assets. I'm done with my claims in favor. At the bottom of page 4, you can see I write there total assets. Hey? That's my total assets. From total assets, I said we need to minus 2 things, right? The first one being liabilities. I then told you there are 2 different types of liabilities, admin expenses and creditors. Go to page 5. You can see my heading, admin expenses. Underneath it, you can see my heading, creditors. Then you list everyone the deceased estate owed money to. You then add your admin expenses and your creditors up, and that gives you your total liabilities. So far the liquidation account reads total assets minus total liabilities. But there's one other thing that needs to be minused, and it's called estate duty. You'll see under total liabilities, I write there estate duty. Total assets minus total liabilities minus estate duty equals the net value of your deceased estate. The correct legal term for net value of a deceased estate is balance available for distribution. Let's apply logic. Why do we call it balance available for distribution? Because once we've minused our liabilities and our estate duty from the assets, whatever is left, we can now distribute it. What was the ranking after we've done with our creditors? It was distributed in terms of marriage, legatees, and heirs. We want to figure out how much is left to give to all these legatees and heirs and to our spouse. The only way to figure that out is to minus your creditors, in other words, your liabilities, and your estate duty from your total assets. That's what's left, is what's available to distribute. The problem we have is that we don't know what estate duty is. We need to minus it. We don't know what that figure is. Now, to put it in layman's terms, ladies and gents, estate duty is tax. If you are rich enough, and you will see as we learn estate duty what I mean by that term, rich enough, wealthy enough, there is a possibility you can be taxed when you die. It is what it is. All right? People above a certain threshold, a certain portion of their deceased estate will go to the government as a tax contribution. Right? We do not know at this stage whether this deceased person owes the government or the state money for tax. So we can't finish the liquidation account, because in order to get that balance available for distribution, we have to go total assets minus total liabilities minus estate duty. That gives us our balance for distribution. We know our assets, we know our liabilities, but we don't know our estate duty. So next to estate duty would be blank. Next to balance available for distribution would be blank, because we can't get that balance without getting the estate duty. So you would stop your liquidation account over there. You will then go over to your second account. Look on page 5. I start my next account. The estate duty account. The purpose of this account is to figure out if the deceased person owes any tax when they pass away. We have to complete our estate duty account. You will see it on page 6 and 7. The answer over there, we then go back to our liquidation account on page 5 and put that amount over there, whatever we calculated. There we can go assets minus liabilities minus tax, which is estate duty, equals the net value of the estate, which is the balance available for distribution. Now, estate duty account, the second account you have to do. You might say, but why don't we just do that account first? Then we don't have to, worry about, then we can just complete the liquidation account one shot. You can't, because the estate duty account requires answers from the liquidation account in order to be completed. And the liquidation account requires the final answer for estate duty in order for the liquidation account to be completed. The two accounts need each other. Remember, I told you the accounts live off each other. They require information from each other. Now, I will venture to say that this estate duty account is the most difficult account. Easily the most complicated account. This is what people tend to struggle with. When we do get to it, I am going to try my utmost best to break it down for you and to make it as easy as possible for all of you. I will also increase our knowledge. What I teach you tomorrow, I might go a step or two further on Friday. I want to just give us the basis. And then on Friday, we can even try to go a step further. But this is definitely the most difficult account, ladies and gents. So when I do get to this account tomorrow, we really got to focus. But luckily, the beauty of it is that Friday we have another chance to look at it again with figures, and things will start to come together. But for now, I want you to understand the second account you do, the estate duty account. It's a calculation. Ladies and gents, it's not a calculation that changes. There's nothing that we made up. This is the law, the tax law. SARS gives us this calculation that we have to work off with. So you have to study this off by heart, right? You're going to go and complete your estate duty account. There's certain calculations here. It's property plus deemed property minus allowable deductions minus rebate equals a figure. 20% of that figure equals estate duty. We'll look at that tomorrow evening. But just so we understand, the second account is to determine if the deceased estate owes tax. Once you've received your estate duty answer, you'll see at the end of on page 7, the final thing there says equals estate duty. I have a question mark there. The answer over there, you go back to page 5. Next to estate duty, you put that answer over there. Now we can finish our liquidation account. Total assets minus total liabilities minus estate duty equals balance available for distribution. That is the net value of your deceased estate. Ladies and gents, that answer is crucial, because whatever you get over there, that is what is left to distribute in the ranking of marriage, legatees, and heirs. You have to start your liquidation and distribution account off like this, with your liquidation account and then your estate duty account. And then you finalize your estate duty account, your liquidation account, once you have your estate duty answer. The next accounts I'm going to show you, you can do in whatever order you like. All right, it's irrelevant. There's no order for it. As long as your liquidation account is first and your estate duty account second, happy days. All right, so you can see the purpose of the liquidation account. It's to figure out what's the net value of the estate, assets minus liabilities. The purpose of the estate duty account is to figure out if we owe SARS any money, if we're wealthy enough to pay an additional tax amount. And we also needed that answer from our second account to complete our first account. Right. Now there's a couple other accounts we need to learn. Now, ladies and gents, these first two accounts I showed you, that takes the most time to learn. That's The liquidation account, I believe, is free marks. You'll start to get that vibe by Friday evening. It just takes long. It's a lot of study work. The estate duty account is definitely the most complicated, but make your notes as I explain it to you tomorrow. Because if you have your notes in place, then when you're studying it, it becomes easier because now you have the notes explaining to you why certain things are being done. That's the key with estate duty. If you're not taking notes while I'm speaking tomorrow, you might find yourself in a predicament later on. Let's look at the other accounts. I told you it comprises of more than just one or two accounts. Look at the third account, page 8, the distribution account. Ladies and gents, if I'm a creditor of your deceased estate, I'm interested in looking at the liquidation account. Why? Because the liquidation account shows what the creditors are going to receive. If I am a beneficiary of your deceased estate, I'm interested in looking at the distribution account, because the distribution account shows who's getting what after the creditors have been paid. So just to illustrate, if we quickly go back to page 5, the bottom of page 5, you will recall our answer we got there was balance available for distribution, right? That is what is left to be distributed in the ranking of marriage, legatees, and heirs. We're going to take that answer, bottom of page 5, that balance available for distribution that we got from our liquidation account. We're going to take that answer and we're going to carry it down into our distribution account. You can see on page 8 on the top, I write there, balance available for distribution brought forward. We're going to bring that figure down into this account. Now, the purpose of the distribution account is to show who gets what. How much goes to your spouse, how much goes to your legatees, how much goes to your heirs. You are now going to distribute that balance in order of ranking. Marriage, legatees, heirs. You can see I first give away to the surviving spouse. Then I give away to the legatees. And whatever is left, I give away to the heirs. That's the ranking. We've learned this. I've already maybe said this 5 or 6 times this week. Obviously, if you are not married or you're married completely out of community of property, there would be nothing to give to your spouse. If you died intestate, you agree there can be no legatees. Because what is a legatee? Someone who receives something specific. How can you give someone something specific? Only if you have a will, right? If you don't have a will, then we've learned the steps on how to distribute. We know you only have heirs then, right? Heirs are those that share in the residue of the estate. Whatever is left, we go and give to our heirs. So the distribution account shows who gets what. Remember, the liquidation account sorted out creditors. Distribution account sorts out marriage, legatees, and heirs. It's a much simpler account, very easy to deal with. You'll see as we go through the week, it will become very, very simple. Now, if you look at these first 3 accounts that we have spoken about, you would actually maybe say, why do we need any more accounts? Because has these 3 accounts not already showed everything? I mean, the liquidation account showed what our creditors are receiving. The estate duty account showed if we owe SARS any money. And the distribution account shows what all our beneficiaries are receiving. So have we not already showed the full picture? Well, to a degree we have, right? And we've also seen how all 3 accounts are dependent on one another. They can't exist without one another. They need figures from one another. But there is 2 other accounts that is very vital. Maybe not for showing who gets what, but it has its place. The next account that we're going to then look at is going to be the recapitulation account. You'll see it on page 9 of the notes. Recapitulation account. Ladies and gentlemen, just give me 10 seconds. I'm just fetching my water over here. Right. This recapitulation account, the 4th account we're looking at, this account doesn't show anything with regards to who's getting what. You would agree we've already showed everyone. I mean, the only people that must get something from a deceased estate is creditors, spouse, legatees, heirs. They're the only people. We've already shown what they're going to get. However, the recapitulation account is a very important account. I call it my practical account. Without this account, we don't know if what we're trying to achieve is going to be successful. Think logically to yourself. In our liquidation account, we set out our total assets. Let's say our total assets was 3 million. And then we set out our total liabilities and we set out our estate duty if we owe SARS any money. Let's say our total liabilities was 1 million. Maybe we didn't owe SARS any money. So what's 3 million minus 1 million? It means our balance available for distribution would be 2 million. I have 2 million to give away to my spouse, my legatees, and my heirs. So you might say, what's the problem? Everything seems in order. The issue we have is if you look at your assets that are 3 million, how much of that 3 million is cash? I can't pay SARS or the bank or Edgar's or Vodacom with a couch. I know I need to pay. If I owe you 700,000 Rand, I must give you 700,000 Rand cash. All your creditors need to be paid in cash. Now, if I tell you you have 3 million Rands worth of assets, does that mean you have 3 million Rands worth of cash? No. Your assets comprise of your house that's still standing there, your car that's still standing there, your movables that's still standing there. So even if my assets exceed my liabilities, the question is, do I have enough cash to pay everyone who needs to be paid in cash? That's the question that has to be asked. Because I might be solvent, I might see no issues on the face of it, but do I have enough money to pay those who needs to be paid in cash? Who needs to be paid in cash? All of your liabilities need to be paid in cash. SARS, your estate duty, has to be paid in cash. And there's even a third possibility. What happens if you have a will and the will says John must receive 100,000 Rand? Can I go and give John a car worth 100,000 Rand? No, I may not, because you were very clear in your will that John must receive 100,000 Rand specifically. So John is a cash legatee. I must also have 100K somewhere to pay John. So you see that there's certain things that needs to be paid in cash. And the question is, do I have enough cash in the deceased estate to pay everyone? So in your recapitulation account, you are not showing who gets what. You are simply calculating two things. Number one, you are calculating how much cash is in the deceased estate. Number two, you are calculating, is it enough cash to pay everyone who must be paid in cash? Now, if you look at this account, you can see I started off by saying cash assets and assets reduced to cash. All right, that's another term for how much cash you have in your deceased estate. And you can see underneath it, I have items and question marks. Just to illustrate what you will do, if you go back to page 2 of your notes, you go back to your liquidation account. Remember I told you all these accounts need one another. Have a look at all your assets, all the ones I made there. The assets run from page 2. The first asset you'll see is number 1. The second asset was the vehicle. It's number 2. You can see I've numbered them. Page 3, I carry on numbering them. Page 4, I carry on numbering them. My assets finish on item 10. So I have 10 separate assets in this fabricated example. You're now going to look at these 10 assets and you're going to look how many of those assets are cash and how much is not cash. Obviously, your money in Absa Bank is cash. Any policies that pay out is cash. But I mean, your car, your firearm, your furniture, your house, that's 10 to 1 not cash. So it's not money. Anyways, I'm going back to my recapitulation account on page 9 now. You go and list under cash assets and assets reduced to cash. You go and list now all the assets that are cash. You add it up and you will get your total cash value of the deceased estate. All right. So now I know how much of those assets are cash and I have a figure. Let's say for argument's sake, I find that out of my 3 million, I have 1.5 million cash. The other 1.5 million is just assets, but they're not cash. That's the first part of my question solved. But now my issue is it enough cash? We said there are 3 potential things that need to be minused from this cash to see if I have enough cash. We said it's your liabilities, it's your estate duty, and any possible cash legatees. Let's say my cash assets were 1.5 million. Now I minus my liabilities. Let's say the liabilities was 1 million. Now I minus my estate duty. Let's say we don't owe SARS anything. Now I minus my cash legatees. Let's say the person died testate and the will said John must get 100K. So I have John that must get 100K cash. So I've got to add John there. Now the answer to the question is, do I have enough money to pay those who must be paid in cash? If I had 1.5 million cash, my liabilities were 1 million and I owed John 100K. That would be 1.1 million, right? So what's 1.5 million minus 1.1 million? It's a positive answer, hey? It's positive 400,000 Rand. So it means if you go your total cash minus liabilities, minus estate duty, minus cash legatees, and if you get a positive answer, it means you have a cash surplus. It means I have enough money in the deceased estate to pay those who must be paid in cash. But let's say I minus my liabilities, estate duty, and cash legatees from my cash assets, and I got a negative answer. That would tell me that I have a cash shortfall, meaning I do not have enough money in this deceased estate to pay those who must be paid in cash. That is going to be a problem, ladies and gents. It means whatever we're trying to achieve, we are going to fail because we're not going to be able to pay our creditors. We don't have enough money in the deceased estate. So what must you do in practice? In practice, you're going to have to start selling some assets. You might have to sell the car, sell the furniture. If there's a huge cash shortfall, you might have to sell the house. Because remember, creditors are ranked first. They have to be paid. So if you receive a cash shortfall, it's telling you you need to sell some assets so that you have enough cash in the deceased estate to pay everyone who must be paid in cash. So it's a problem. Now, from a practical viewpoint, ladies and gents, I strongly suggest that you don't just start selling assets willy-nilly. That could really upset the beneficiaries. Even though the beneficiaries don't have a say, in the sense that the creditors, the estate duty, and the cash legatees are ranked above them, so they can't prevent it. But what you could do is you could have a discussion with the beneficiaries and perhaps ask them, is there certain assets that they really don't want me to sell? Perhaps assets that are of sentimental value. And then I'll try my best not to sell those assets, because they've requested that we try not to sell it. Rather sell the other assets. Get direction from your clients in terms of what assets we try our best not to sell. That's the right thing to do because they are the ones ultimately who's going to inherit these things. Just to give you an example of this, I remember a deceased estate where I did the recapitulation accounts and I saw we had I think it was like 140,000 Rand shortfall. So I notified the beneficiaries and I told them, look, we're going to have to sell some assets. Okay, cool. I had a look at it and there was no assets that had enough value to reach 140K besides the house. The house was valued at around, I think it was around 2 million. Now, unfortunately, I need to sell the 2 million Rand asset to raise 140K shortfall. It doesn't sound, very practical, but it is what it is. You have to pay the shortfall. So I spoke to my clients, all the beneficiaries, and I said that there were the two children of the deceased, and I said, look, I have to sell this house, because we need to raise the shortfall. And they said, is there any way we can avoid not selling the house? Because they wanted to keep the house because they wanted to rent the property out. And they were going to split the rental income, whatever it is. Maybe it was 9,000 Rand each per month. But they saw it as a great future investment. I mean, the rental income is just additions on top of their salary. And I agree with them. And I explained to them that, there's no other assets that are of enough value, unfortunately. And they asked, can't we contribute? And I said, you most definitely can. They said they are willing to each pay 70,000 Rand. They are willing to put 140,000 Rand. So they're willing to donate 140,000 Rand to the deceased estate, just so that they can keep the property, because it made more financial sense for them to pay 140K for a 2 million property than to just lose the property to raise 140K to pay creditors. And it made sense. And I said, great. They each paid the 70K in, and I was able to then cover the cash shortfall. Now I'm telling you this story because if I just decided to start selling assets, I would have never given those beneficiaries the opportunity to make another plan like they did. And they would have lost that house, when actually they would have preferred to just donate money so that they can keep the house. Hence I'm saying, always speak to your clients. See if you can work around it. Speak to the beneficiaries, because everything we're doing affects them. It doesn't affect you, it affects them. Right? So if you do your recapitulation account and you see a cash shortfall, speak to your clients about it. But hopefully we have a cash surplus and we don't have any issues along these lines. So you can see with the recapitulation account, we're not showing who gets what. We are simply just seeing if what we are trying to achieve, is it practical? Are we going to be successful? Is there enough cash to pay those who must be paid in cash? So that is the purpose of this account. It's a practical account, just to figure out if we have enough cash. That's the only reason to it. But you can see it's important. It's obviously vital that we do this account, and you can also see how this account relies on the other accounts, right? Because we took figures from the liquidation account in order to complete this particular account. So again, all these accounts are dependent on one another. Now there is one more account we have to learn. Go to page 10, the income and expenditure account. You might think, why possibly do we need another account? Surely we've covered everything. There is one more account, income and expenditure account. Ladies and gents, this is the only account that has absolutely nothing, or let me rather say, has absolutely nothing to do with any of the other four accounts. You saw those other four accounts. They all needed each other to be completed. They all lived amongst each other. They were all very vital to finalizing the deceased estate, to drafting this liquidation distribution account. This account, however, plays no part with the other four accounts. It's totally separate. As a matter of fact, if you put a figure in this account, and that figure you put in there is in any of your other accounts, you know you've made a mistake. It's completely separate, this account. And I'll explain to you why after I've taken my sip of water. Right. Just to quickly go back to that liquidation account, I think this is the easiest way to explain it. In the liquidation account, we listed all our assets, all our liabilities, etc., etc. Now, how it works is your liquidation account represents what you are worth or what you owe the day you die. It's your assets as per date of death. It's your creditors as per date of death. That all got placed in the liquidation account. And that account affected the distribution account, it affected the recapitulation account. I mean, all those figures affected all of the other accounts. I mean, we've looked at that. Your income and expenditure account does something different. Now, hear me out when I say this. Once you have passed away, you cannot purchase an asset. If you've passed away, you cannot purchase an asset because you'll need to sign to purchase it or physically go and purchase it. It cannot happen. Once you have passed away, you cannot enter into a liability. Because how do you enter into a liability? You have passed away. However, your deceased estate can make money and can lose money after you have died. That can happen. Now, remember what I said. The liquidation account represents your assets and liabilities the day you die. It does not account for any money that the deceased estate made or lost after date of death. Now let's think practically. How can you make money or lose money if you are dead? Well, very easy. Bank accounts. Bank accounts is what is the primary factor to this account. Let's think logically. When you passed away, there was probably a funeral, and then, you know, family members approached the attorney, and the attorney reported the deceased estate, and the executor waited for the letter of authority. I mean, this is not days, we are talking months to get this letter of authority now. Now the executor goes and they want to start winding up the deceased estate. What was step 2? Open a bank account, transfer all money into that bank account. What happens if you passed away and you had R1 million in your savings account, and that was going interest at 6% per annum, for argument's sake? 3 months later, I go as executor and close down that account. But is it still R1 million? No, it's running at interest. I mean, 6% of R1 million is 60K. 60K divided by 12 is 5K. Divided by 3, because it's 3 months, is 15,000. So that account should be worth plus minus R1,015,000. Did you see the day you died, you had R1 million asset in your Absa savings account? However, after date of death, that account wasn't closed. So that asset accumulated interest, an extra 15,000 rands worth of interest. Now that's where we're going to show that interest, in our income and expenditure account, obviously under the heading income, because we have made money after we died. Another example would be you own an apartment that you are leasing out. Let's say your rental income is 10,000 rand a month, for argument's sake. You die as the owner of the flat, you die today. Does the tenants move out? No, the tenants stay in the property and carry on, you know, paying rent to the deceased estate until their contract is terminated, until their lease is finalized. Now, those tenants are paying 10,000 rand a month, but you don't live. This is happening after you've passed away. So do you see how your estate is making income even after you have passed away? You didn't gain an asset, you're just making income. So it can happen. On the same breath, your deceased estate can lose money after you pass away. Let me give you an example. You have 2,000 rand in your Absa check account the day you pass away. 3 months later, I as executor want to go and close down that account. Now there's no longer 2,000 rand in it. There's only 1,500 rand in it. How did you lose 500 bucks over 3 months? Think logically, ladies and gents. Bank charges. Your money was in the bank account and there was bank charges accumulating every month after you passed away. You see how you did it? You did not enter into a liability, but you lost money through bank charges after date of death. Now, all the money you make and all the money you lose after date of death gets shown just in this account, in this income and expenditure account. You list your income and you list your expenditure. Now, ladies and gents, if you made 10,000 rand income and you lost 5,000 rand in expenditure, do you agree you've made a net profit of 5,000 rand? Income minus expenditure gives you amount. If you've made a net profit of 5,000 rand, the question you have to ask yourself is, where does this 5,000 rand go? It's not mine. It's not mine as executor. That must be given to the beneficiaries, right? But I've already done my distribution account. Remember, the distribution account is I gave to my beneficiaries what was left after my liquidation account. So I have not accounted for this 5,000 rand anywhere. It's just an extra 5K. Surely I need to give it away. So when you've done your income and expenditure account, if you look at the bottom, you can see I write there, balance available for distribution. You then go and give it away in order of ranking. Spouse, legatees, heirs. In other words, it's a 2-in-1 account. You do your income and expenditure account. Whatever additional income there is after date of death, you give it away the same way you did your distribution account, in ranking of spouse, legatees, heirs. Now you will look there and say, but Carl, I don't see legatees, I see spouse and heirs. Because I'm trying to make it realistic. What is a legatee? A legatee is someone who gets something specific, right? In my example, I said we had one legatee, it was John, and we gave John 100K. You agree in my distribution account, I would have given John the 100K already, right? Can I give John anything else? No, I cannot, because the legatee gets something specific. So majority of the times you would have already given the legatee that something specific in the distribution account. So there's nothing more to give them. So if you make additional income after date of death, you will give it away in ranking, yes, of spouse, legatees, heirs. However, the legatees would have already probably been sorted. So you just give it away in terms of spouse and heirs. So it's sort of that 2-in-1 type of account. And the reason why we do a little distribution account at the end of it is because these figures in this income and expenditure account have not been portrayed in any of the other accounts, because the income and expenditure resembles money made or lost after date of death, and that is not reflected in any of the other accounts. Very, very important, ladies and gentlemen. That is the accounts we've got to learn. If I ask you to draft a liquidation distribution account, this is what you've got to draft. Now, just to recap, liquidation account, very relevant. Why? Because it was total assets minus total liabilities minus estate duty, and that gave us our net value, balance available for distribution accounts. The estate duty account, very relevant, because it shows us if we owe SARS any tax money. And once we got that answer, we actually carried it back into our liquidation account so that we could finish our liquidation account and get that balance available for distribution. Thereafter, we did our distribution account. We gave that balance that was available, we gave it away in order of ranking, marriage, legatees, heirs. Thereafter, we did a recapitulation account. And we said, well, we're not giving anything to anyone. We're just trying to see, do we have enough cash to pay those who must be paid in cash? So we add up our assets that were cash, and from there we minus everyone who needs to be paid in cash. We said there's 3 potential things that need to be paid in cash. Your liabilities, your estate duty, and then possibly cash legatees, if there was a will that had any cash legatees. And then we can see if we have enough money to pay these people. When we're done with that, we move over into the income and expenditure account. The only account that has nothing to do with the rest, and that resembles money made and money lost after date of death. Whatever money we made after date of death, we need to give away to the beneficiaries. It's not our money, right? We give it away, and we give it away in the same ranking as what we did our distribution account. So you can see, ladies and gents, there's our home for everything. All these accounts are necessary, and they play a vital part in their own way. This is what gets advertised in terms of step 5. Hey? This is what we hope is perfect so that no one objects to us in those 21 days. Now, there's a lot of study work. I mean, you need to know this stuff off by heart, ladies and gents. It is what it is. But once you've done this and written it out a couple times, it's almost like driving a car. Once you start shifting through the gears and you feel comfortable behind the wheel, it's the easiest thing on earth. But you have to study it, you have to practice it, you have to write it out. And my concern is not you studying it, because if you sit behind your books, you will study it. That's on you. My concern is that you understand what you're studying. And that's what I want to spend tomorrow and Friday going through with all of you. So we're going to try follow a simple and clear pattern. What you would have noticed from these accounts is, firstly, your liquidation account is probably your longest account. Secondly, your estate duty account is probably your most difficult account. So I want to focus on those 2 accounts tomorrow. Now remember, we're focusing about talking about it, explaining it, making notes. All right? That's what we want to do about those 2 accounts. And we are going to feel a bit shaky about it at the end of the lecture tomorrow. That's normal. It's okay. All right? Friday then, we're going to focus on the other 3 accounts, the distribution, recapitulation, and the and the income and expenditure account. Ladies and gents, that's going to take us half an hour. All right? It's much easier, it's quicker. I want to do the 2 tough ones tomorrow. All right. Friday, we do the 3 easy ones, will take us half an hour. But because it's only going to take us so short, it's then going to give us the opportunity to go through the exam question and memo together. It is then, ladies and gents, that things start clicking. Because then we look at the question, we look at the answer, and we go, okay, so that's what Carl was talking about, in other words. And now you start to see some things for the second or third time instead of for the first time anymore. And things start to become easier. So there is a journey, there is a method to what we're going to try to be doing. We've got to be patient, we've got to listen carefully, we've got to take our notes, and things will get easier as we get along. Ladies and gents, you do know, tomorrow evening at a certain stage, I will open the floor for questions. Same on Friday evening as well. So if there's something that's prickling you that you're not quite getting, understand, keep your note, make a note of it. We will get to questions as well then. So in a nutshell, that is what we're going to learn tomorrow and Friday. All right. It is not the easiest thing on earth, but I'm going to try and explain it to you that it becomes easy and boring. That would sort of be the aim behind it. All right. Ladies and gents, I think we've progressed nicely for the evening. It is around the 8:30 mark. So we're going to call it for the evening. We come back at 5:30 tomorrow, and we start looking and learning on how to draft these particular accounts. Have a good evening, everyone.
But before you leave, hello, sir. Hello. It's gone.
Sinatra?
Hi, everybody. Yes, I just wanted to find out. You mentioned that the accounts, it's 6 of them, but you only mentioned 5. I don't know whether there's something that I left.
No, it was my error. It was just 5.
Oh, all right, no problem.
Cool. All right.
Okay, man.